So, California section of law in the government code, as you might expect, concerning the operation of statutes and resolutions. These statutes were actually enacted in 1943. They're found in a government code Title II, Division 1, Part 1, Chapter 6. And I'll go through them. Government Code Section 9600 deals with the effective date of statutes. And with certain exceptions that are actually found in the Constitution, a statute enacted at a regular session goes into effect on January 1, next following a 90-day period from the date of enactment of the statute. And a statute enacted at a special session goes into effect on the 91st day after adjournment of the special session at which that bill was passed. The only exceptions are statutes calling elections, statutes providing for tax levies, statutes providing for appropriations for the usual current expenses of the state, that is the budget bills, and of course urgency statutes, because those four statutes go into effect immediately upon enactment. The next is Government Code Section 9602, dealing with the effective date of resolutions. And it says that every concurrent and joint resolution, both of which have to be adopted by both houses of the legislature, those take effect upon the filing of the resolution with the Secretary of State. And the Secretary of State assigns a chapter number, a resolution chapter number, to every concurrent and joint resolution. The next is Government Code Section 9603 on general rules of statutory construction. And it says that the general rules for the construction of statutes are contained in the preliminary or general provisions of the 29 different California codes. Government Code Section 9604 deals with restatements of statutes. And this code section provides that when the provisions of one statute are carried into another statute, under circumstances in which they're required to be construed as either restatements or continuations rather than a new enactment, then it says that any reference made by any statute to such provisions must be deemed a reference to the restatement or the continuation. Then there's Government Code Section 9605, which deals with repealed statutes. And it says that if a statute or a part of a statute is amended, it's not considered as having been repealed and reenacted in its amended form. The portions that aren't altered are considered as having been the law from the time when those provisions were originally enacted, and the new provisions are considered to have been enacted at the time of their amendment. And the omitted portions are considered to having been repealed at the time of the amendment in which they were omitted. And so when the same section or a part of a statute is amended by two or more acts that are enacted at the same legislative session, then any portion of an earlier statute that's omitted from the subsequent act is deemed to have been omitted deliberately, and any portion of a statute admitted by an earlier act that's restored in a later act is deemed to have been restored deliberately by the legislature. And then it says that in the absence, and this is still Government Code Section 9605, it says that in the absence of any express provision to the contrary in a statute that's enacted last, it's conclusively presumed that the statute which is enacted last was intended to prevail over any statutes that were enacted earlier at the same legislative session. And so this is the so-called chaptering out rule. And again, it's found in Government Code Section 9605. Government Code Section 9606 deals with vested rights, and it says that any statute may be repealed at any time, except when vested rights would be impaired. And so persons acting under any statute need to act in contemplation that there is the power to repeal that particular statute, again, except those which would impair a vested right. Government Code Section 9607 deals with the lack of revival of a repealed statute, which hopefully makes sense. With an exception, no statute or part of a statute that's been repealed by another statute is revived by the repeal of that repealing statute without some express words that would revive the repealed statute. Government Code Section 9608 deals with termination or suspension of laws. And it says that the termination or suspension of any law that creates a criminal offense does not constitute a bar to the indictment or information and punishment of an act that was already committed in violation of a law that is then terminated or suspended, unless the intention to bar that indictment or information is expressly declared in the law. Government Code Section 9609 dealing with amending a repealed statute is hopefully another obvious one. That government code section says that a statute amending a section of a repealed statute is void, of course. Government Code Section 9610 deals with fixing public salaries, and it says that the fixing or authorization of the fixing of a state officer or employee salary by state statute is not intended and does not constitute an actual appropriation of money for the payment of that salary of the officer or employee. And then lastly is Government Code Section 9611 dealing with suspended provisions of laws. And here it says that whenever a provision of law is temporarily suspended, or it's been expressly or impliedly modified or repealed by a provision which is declared to be effective for only a limited period of time, then that original provision of law is not deemed actually repealed. However, upon the expiration of the time of the temporary suspension, then the original provision has the same force and effect as if the temporary provision had actually not been enacted. So these are provisions of the California Government Code that explain how statutes and resolutions in the California state legislature actually operate.